Good morning, it's Alex Woods here. I am running a series of video bulletins on the issue of PPI and insolvency following the guidance that was issued by the RPB last week. And I've done it in a 1 to 10 order because I think there are sort of 10 central questions that come out of the guidance, at least there are for me. And I wanted to complement and supplement the guidance, not in an academic kind of a way, but because I work in the sector and because I have contact on a daily basis with financial and selling claims and with insolvency practitioners and with IVA proposals, to kind of actually transmit the knowledge that I'm gaining as we go. So it's just something, this idea, because it is at the moment just an idea, and God only knows if anybody's actually bothering to listen into it, is a way of perhaps building some sort of consensus of best practice as far as small and medium-sized insolvency practitioners are concerned. To give you an example of what I'll use the questions and the little legalities and try and expand on what I think the guidance is kind of really saying, if necessary, just to flesh it out. But I will use that as the sort of the starting point for the bulletin, but I'll then talk more generally about the practice of it, and as I say, we'll try and bring in real life examples and experiences. So for example, you may be thinking, well, what's the cost to me of having to get involved in this whole PPI and insolvency thing? And you may have heard claims management companies and others talking about the fact that there are apparently 3.2 payment protection insurance claims per IVA of an average of £1,800 in value. That's an industry standard that I worked to when I first got into the sector 2 years ago. Is it true? And I now have through the experience of working with a couple of firms, and as I say, this is an ongoing thing because we are currently processing hundreds of IVA claims at the law firm. I'll be able to tell you whether those figures are accurate or not. And please feel free to email or phone if you want to know more. I feel there's only a certain amount of commercial information I can disclose, but I can disclose quite a lot, and I am a non-exclusive consultant. So the second example that I'd like to give you is just, actually seeing what's happening in practice. So this is what I'm shuffling papers here, is because I've got a letter that I received yesterday in response to this is a closed IVA. As I say, this is just a taster of what's to come as we move through the questions and the episodes. This is a non-status lender. It's Capital One. I don't think there's any reason that we don't disclose the name of this particular non-status lender. This is the position that they are adopting in response to our PPI complaint, which I think is quite interesting. I'm going to quickly read it out, just the relevant section. Your client entered into an IVA in 2006. And therefore any claim for payment protection insurance should have been declared to your client's creditors as an asset at this time, and not at this late stage when the IVA has ended. It then goes on in quite sort of an aggressive way to hold our client to account for having failed to make full and frank disclosure, as they're required to do under the Insolvency Act, of the PPI asset, even though in the case of this particular IVA in 2006, very few people knew that there even was a PPI mis-selling scandal. And indeed, even though Capital One themselves were fined by the FSA, I think in 2007, for their mis-selling breaches. So there it is. That's the sort of thing that, but before, by the way, you even get on to the issue of whether or not the PPI was an asset that could be caught by the IVA, Capital One waded straight in with accusing our client of being dishonest, frankly, and failing to give full and frank disclosure. So it's quite a rich and amusing letter, and that'll be fun taking that forward. Now, I urge you to listen to these video bulletins because this is where I do a mini pitch, because you can learn about me on the introductory videos on the site. But I do have contact with a lot of IPs, as I say, and I do actually have sort of hands-on litigation experience with all of the major banks, credit card companies, etc. That being said, what I don't have is an in-depth knowledge of the insolvency sector yet. And as I say, I would like this to be a, what's the word, proactive, interactive type video bulletin series. And if you would like to pull me up on a point that I've got wrong, or give me your own anecdote and your own experiences of a claims management company or a law firm, or dealing with lenders, or the legal issues that I will be fleshing out in the guidance note, then please do so. If it's general, please comment, and if it's more specific or confidential, then please do email info@redwoodlegal.co.uk, info@redwoodlegal.co.uk, and I will use the knowledge with obviously preserving the issue of confidentiality. I see this as something that's kind of really needed. I'm a non-exclusive consultant who's in the process of setting up a law firm that's taking forever. I feel like I feel like a cracked record sometimes. It's taking so long for the SRA to grant my authorisation. Anyway, for the moment, I'm a consultant, and as I say, non-exclusive is important. I have single percentage deals with a law firm and a claims management service company to help them to process PPI within IVAs. I think this is important because, particularly for small and medium-sized IPs, not everyone has a large IP with hundreds or thousands of IVAs, and there's obviously we all live in our own little world. So this is kind of a way of connecting everybody together, I suppose, and developing some sort of a best practice consensus amongst insolvency practitioners and lawyers working in the sector going forward. This is not a video bulletin that's designed or aimed at the larger insolvency practitioners who have different requirements. For a start, they're probably quite clearly driven towards profits and dividends to shareholders and so on and so forth. So there it is. The first posting will be on the issue of whether or not payment protection insurance is caught as an asset at all within an IVA. And I'll also find some other interesting, juicy nugget of knowledge for you to listen into at that time. So once again, I don't know if I've mentioned it in this bulletin here, but I'm a member of a PPI and insolvency group on LinkedIn, and I think there are currently 43 members on that discussion group. So by all means, you can sign up to that and participate in that discussion. By the way, I have a half-brother, Jamie Thompson, who runs Redwood Assist, and he's a salesman and marketing business development dude, and in fact he's hosting that website. I say that because I think transparency is very important in this area. So many thanks, and I hope you enjoy the episodes as they roll out over the coming weeks.